Seguimos con la segunda conferencia magistral de esta mañana. Estereotipos de género, perspectivas legales transnacionales. En esta segunda conferencia, la señora Rebecca Cook presentará la afectación que producen los estereotipos en materia jurídica y cómo las posturas estereotipadas de legisladores, jueces, líderes religiosos y proveedores de salud se convierten en una violación de leyes de derechos humanos que prohíben la discriminación en contra de la mujer. Invitamos a que se suban al estrado, por favor, a la doctora Rebecca Cook, y esta conferencia estará coordinada por la señora Natalia Gerardi. Natalia Gerardi es abogada por la Universidad de Buenos Aires y máster en Derecho por el London School of Economics and Political Science, directora ejecutiva de ELA, Equipo Latinoamericano de Justicia y Género. Las recibimos con un fuerte aplauso.
Como mencionaba ayer Alicia Yamil en su conferencia, cerrando el primer día de nuestra reunión, el derecho y el poder judicial claramente es mucho más que solamente un mecanismo de resolución de disputas. A través del derecho también hay un carácter expresivo de las normas, de los estándares y de las formas en que las personas, nuestras experiencias, nuestras vivencias se reproducen en la sociedad. Entonces, la conferencia que vamos a escuchar esta mañana de la profesora Cook va hacia una parte central de ese poder expresivo del derecho, que es los estereotipos de género y la forma en que los estereotipos de género limitan la forma en que los derechos son ejercidos por diferentes grupos de personas. La profesora Rebecca Cook es profesora emérita de la Facultad de Derecho, de la Facultad de Medicina y el Centro de Bioética de la Universidad de Toronto en Canadá, así como codirectora del Programa Internacional en Derecho y Salud Sexual y Reproductiva de la misma universidad. También es la actual coeditora de Asuntos Éticos y Legales del International Journal of Gynecology and Obstetrics y miembro de la Orden de Canadá y de la Royal Society of Canada. Entre sus publicaciones más recientes se encuentran Estereotipos de género, perspectivas legales y transnacionales, en coautoría con Simone Cusack, y El aborto en el derecho transnacional, casos y controversias, en coautoría con Joanna Edman y Bernard Dickens. Profesora Cook.
Thank you, Natalia, and thanks and ever thanks to the organizers of this conference. I have to say, as an academic, to be invited to such a conference and try out your ideas is an incredible honor for me. I stand here hoping that you will be critical of these ideas and think about how you can push academics to create and think together with you about creating new ideas that will grow this field. My work has been recently on gender stereotyping and looking at different national, regional, and international court decisions analyzing how they have named gender stereotypes. Next slide. The outline of my talk is to think together with you about what your argument might be in terms of why do societies continue to oppress women. My argument that I'm working on right now is that the elimination of discrimination against women requires understanding the pictures in our heads, the stereotypes that contribute to the degrading social practices of gender. What I want to do is look at the term gender, the term stereotyping, and a methodology that I, together with my co-author Simone Cusack, have developed on stereotyping, and apply that to cases, sexual assault cases, then reproductive health cases, and then review my argument at the end and see whether I've convinced you. Next slide, please. So I've said that my argument is that we have to be aware of the pictures in our heads. We have to be aware of the prejudices that we all have. We have to be aware of how those prejudices get perpetuated by stereotypes. Another way of thinking about it is to look at biased assumptions and even how we stigmatize. But unless we can understand how we have our own prejudices, stereotypes, biased assumptions, and how we stigmatize, we are ill-equipped to eliminate discrimination against women. Stereotyping is one of the quickest ways that prejudices spread. Stereotyping is a technology of prejudice, a technology of stigma. And it's very important that we understand not only stereotypes, prejudices, and assumptions, biased assumptions against women as a collective, but also against subgroups of women, such as Indigenous women and poor women. The stereotypes and prejudices can vary. Next slide, please. So, in terms of thinking about the term stereotyping, stereo comes from the Greek word which means firm, and type means mold. It was borrowed from the French. The French used it in the 18th century to refer to imprints that printed pictures. Psychologists borrowed it to think about pictures in our heads. Gender stereotypes relate to the physical, biological, sexual, and cognitive attributes that we associate with women and men. Essentially, it is the social and cultural practices of gender due to these particular attributes, whether it's physical, sexual, biological, cognitive, or social. Stereotypes take many forms. Gender stereotypes that I want to focus on relate to prescriptive norms, what we think women should do in society. In the sexual health field, we deny women services, whether it's family planning, whether it's abortion services, because the picture in our head is that women should be mothers. And unless we understand that prejudices, it's very hard to change laws and policies. The other stereotype, the kind of stereotype I will be dealing with, is a false stereotype. These are downright lies. So we think in the sexual assault field of women as liars. They've been assaulted, and because we're so ashamed that a society allows for sexual assault, we victimize women and we call them liars. So that's a false stereotype. I'll come back to these kinds of stereotypes as we go through the particular cases. Now, in thinking about raising consciousness about stereotypes, it's very important to name the stereotypes, to identify the picture in our head that allows us to degrade somebody. It's important to expose the harms, the discriminatory consequences. Sometimes those consequences are miscarriage of justice, and I'll be dealing with those miscarriages in particular contexts. It's important to understand the context, because the context requires you to look at the means of perpetuation. And the three contexts I will be dealing with in this talk: the criminal justice context, the military context, and the health context. Finally, the methodology requires thinking about how we can best dismantle stereotypes. Judges do it by naming the stereotype embedded in the law that can help dismantle it. That's a step. But I'll go through each of these cases applying this methodology, knowing that you will think critically about whether this methodology works for you. Next slide deals with, where does this law come from on stereotyping? The transnational law on stereotyping is dynamic. It percolates up from domestic court decisions and comes down from international conventions like the Convention on the Elimination of All Forms of Discrimination Against Women, or the Convention Bellum do Para. They all have provisions requiring states to modify the social and cultural patterns of conduct to eliminate prejudices and practices based on the inferiority or superiority of either of the sexes, or on stereotype roles for men or women. This same provision with minor adoptions was instituted in the Convention Bellum do Para. And this has been picked up by domestic courts and by, I will focus on the Inter-American Court of Human Rights and the Inter-American Commission. So let me proceed by applying this methodology of naming the stereotype, understanding its harms, understanding its context, and how courts have thought about dismantling it. And I'll do so by referring to 4 different cases. One is the Algo de Nero case, the famous case that had been referred to by Judge Garzon. The Inez Fernandez Ortega case, another decision of the Inter-American Court of Human Rights on the rape of an indigenous woman by the military. The Bustamante decision of the Colombian Council of State about a rape of an adolescent girl by a military. And finally, a case that's pending against the U.S. military for failure to address sexual violence of military personnel against their military comrades. I'll go through each of these cases using the methodology that I outlined. So with Algo de Nero, this is an absolutely remarkable watershed decision. It's a watershed decision for many, many reasons, but I want to focus on its reasoning around false stereotypes. This decision named the false stereotypes that were used by the police against the victims that were tortured and disappeared. When the complaints by their mothers, their families were filed, the police simply said, these victims were leading disreputable lifestyles. They were promiscuous. Therefore, they're just out fooling around, and we do not have to investigate. They made these false stereotypes because they were covering up. They were covering up their failures to investigate. So in naming these false stereotypes, the court made a huge advance. It showed how the police were blaming the victim. In terms of dismantling the stereotype, in addition to the judicial recognition of the false stereotype, they called for training of the police. The police had categorized these victims as unworthy and dealt with them according to that category of being unworthy, and did not treat them as individuals with particular needs in the criminal justice system. Now, I can't leave this case without recognizing Cecilia Medina, who at the time was president of the Inter-American Court of Human Rights. And it was her vision, her courage, that called out these stereotypes. And I hope we can really contribute to the legacy that she has left us by doing the same. The next decision deals with the rape of an Indigenous woman by the Mexican military. The decision of the Inter-American Court recognized the prejudice against Indigenous women as lesser citizens by finding a violation of the right to equal access to justice of Mrs. Ortega and her family. The denial of equal access to justice in the military system, the court said that now Mexico has to take these cases out of the military justice system, which is embedded in a system of sexism and impunity, and put it in the civilian system. They called for military training, both in terms of gender discrimination and ethnic discrimination. The next slide deals with the Gallagher case. Next slide, please. The Gallagher case is a case brought on behalf of women and men in the military that have been sexually assaulted by their military comrades. This is a case brought by the American Civil Liberties Union on behalf of these military comrades. Because the U.S. military has failed to address the sexual violence that's so pervasive in the military. They've exhausted all the remedies in the U.S. system. It's a case now pending before the Inter-American Commission on Human Rights. The complaint names the hostile stereotyping of these victims as lacking professional competence. They're incompetent, therefore it's fine to abuse them. Hostile stereotyping of their sexuality. They're whores, they're sluts, therefore we can abuse them. Hostile stereotyping of their truthfulness. They're lying about their sexual assaults. Therefore, we don't have to give them justice. The harms of these 20 women and men include military sexual trauma relating and causing post-traumatic stress disorder. The military, particularly the U.S. military, is riddled with sexism, misogyny, and impunity. We have yet to see what will happen with this case. But the kind of labeling, the hostile labeling that's taken place in the U.S. military takes place all the time when an out-group joins an in-group. So when an out-group, like women, join an in-group, male military men, hostile labeling emerges. And you see this time and time again, not only in the military context, but in Algo de Nero, where you had poor migrant women immigrating into a place. And they didn't like it, and therefore they started doing this hostile stereotyping. We all do it. Just think of yourselves when you're in a situation where new people come in. You don't discipline yourself to treat people with dignity. So when left unchecked, this hostile stereotyping leads to degradation. It contributes to a culture of impunity that encourages sexism, misogyny, that allows for continual sexual violence. So stay tuned for the decision of the Inter-American Commission in the Gallagher case. So now I want to review with you The cases concerning sexual assault. What have we learned from these cases? What do you want to share with each other? How can we build upon these cases to develop the law? These decisions, the first 3 decisions, are absolutely remarkable for recognizing and naming the hostile stereotypings. This is a judiciary in many different contexts, whether it's the Inter-American Court, whether it's the Colombian Council of State, that has evolved to understand how false stereotyping have discriminatory context. The naming in the Bustamante case of women as the sexual property of men, and therefore it was all right for them to be raped, was instrumental in the decision that they made, finding a violation of this woman's rights. They also showed how these biases led to a denial of access to justice. All of these cases require training. Now, I'm all for training, and I think it's a very important first step. But we need, as we build this field together, we need to think very carefully about how to develop training that is really effective in dismantling patriarchal structures perpetuated by hostile stereotyping. We need to work together with social psychologists such as Jose Luis Alvaro, who I'm very pleased is here with us from Madrid, to really analyze how we can develop training in a way that develops positive pictures of women, that dismantles patriarchal structures. These are not easy things to do, and lawyers cannot do it on their own. We need to work in an interdisciplinary manner and in a common sense manner with people who thought far more carefully about this than we have. So those are what I've learned from the sexual assault cases and stereotyping. I'm sure you have your thoughts as well. Let me turn now to the reproductive health cases. And here I want to deal with 3 cases and then the role of the health professions in beginning to identify stereotyping in the health sector. I want to deal with the Constitutional Court case of Colombia 2006 that liberalized that Colombian restrictive law, a very famous case. I want to next deal with the Carhart case, the U.S. Supreme Court case, which I might say is infamous. Then we've all heard about the LC case, but my take on the LC case is to look at how the Committee on the Elimination of Discrimination Against Women dealt with the prejudices and stereotypes in those cases. So with regard to the Colombian case, this famous case that was brought by Women's Link Worldwide, absolutely remarkable case that named this stereotype of reproductive instrument, which has resonated around the world. It says, and I quote, "When the legislatures enact criminal laws, it cannot ignore that a woman is a human being entitled to dignity and that she must be treated as such, as opposed to being treated as a reproductive instrument for the human race." So the naming, the very naming of the stereotype helps change the picture in our head. The second thing I want to point out about this decision is this use of this principle, a fancy criminal law principle that's called ultima ratio. Essentially, that principle means that the threat of criminal punishment should only be used as a last resort. Only be used as a last resort. You might be saying, But when it comes to women and reproductive health, criminal law is used as a first resort, not as a last resort. The Colombian Constitutional Court used this last resort principle to strike down the near ban on abortion, because the legislature had other means of protecting prenatal life that did not infringe women's rights. As Veronica Unduraga, a noted Chilean legal scholar, has explained in her work on proportionality, the criminalization should be avoided when the state has less restrictive means to achieve its objectives. Such means, and you all have ideas, such means might be addressing the causes of unwanted pregnancy, such as rape. Such means might include violence against pregnant women. So we need to think together about how we can deconstruct, how we can critique, how we can criticize courts when they use this ultima ratio principle to uphold restrictive laws. And we need to cite to the Colombian Constitutional Court. Now, the next case is an infamous case of the U.S. Supreme Court. And because of their provincial approach to constitutional law, they probably hadn't read the case of the Colombian Constitutional Court. It's an infamous decision because the Supreme Court outlawed a method of abortion that might, in certain circumstances, be safer for women in the judgment of doctors. How did they do this? They did it, the majority did it, by painting a picture of women as irrational and incompetent. The dissent, Justice Ruth Bader Ginsburg, the only woman on the court at the time, took them on. And she criticized the majority for depriving women of the right to make an autonomous choice, even at the expense of their safety. This way of thinking reflects ancient notions, she said, of women's place in the family and under the constitutions, long since been discredited. Essentially, the majority infantilized women to uphold a congressional law that allows for the use of abortion that's less safe. This is the ultimate in judicial paternalism. Now, moving on to the LC case, you all know about this tragic case of a 13-year-old who was sexually abused. She was denied surgery for her spinal cord injury by the hospital board because she was pregnant. The decision to postpone her surgery due to her pregnancy was based on prejudices of the members of the hospital board. Prejudices that the interests of the fetus should prevail over the interest of a 13-year-old girl. Prejudices that treating a girl according to pictures, according to stereotypes of women as reproductive instruments instead of their own medical needs is okay. Prejudices that it's okay to blame a 13-year-old girl for sexual abuse despite her attempted suicide. So these were the kinds of prejudices in the members of the hospital board that enabled them to deny LC a necessary, lawful, therapeutic abortion. The Committee on the Elimination of Discrimination Against Women explained that Peru had failed in its obligation to eliminate gender prejudices in these minds of the hospital board that allowed them to deny her necessary medical treatment. In other words, the prejudices allowed the hospital board to develop its own informal rules that arbitrarily denying LC a lawful therapeutic abortion is okay. Let's move on to think together about how professional medical associations might develop guidelines, ethical standards to deal with harmful stereotyping. And here I want to cite to the International Federation of Gynecology and Obstetricians, their ethical guidelines on harmful stereotyping. And I want to ask you to think about how we might avoid harmful gender stereotyping in the health sector, how we might encourage every health professional to treat pregnant women according to their own health needs and not according to pictures in their heads, not according to prejudices. Now, the FIGO ethical guidelines have developed such a guideline, which is available in Spanish on the FIGO website. But I'm sure these guidelines could be built upon. Dr. Luis Tavara of the Peruvian Society of OBGYNs, a giant in my mind, Dr. Marta Rondo of the International Association of Women's Mental Health. I'm sure working together with them in their own respective medical bodies, they could develop even better guidelines. Full disclosure, my husband was the chair of the FIGO Ethics Committee when these guidelines were adopted. So I pushed him, but I want to hear of even better guidelines in the future. So in reviewing what we've learned about the cases and the guidelines on reproductive health, all the cases are available on the website that I've discussed. All the reproductive health cases are available on the website. The Colombian case, as I mentioned, is famous for its naming of women as reproductive instruments. And without that naming, I'm not sure the decision would have been as dramatic. We understand now, through the Carhart decision, that judges can infantilize women, and that leads to discriminatory contexts. The use of the informal rules in the LC case suggests that we need more research on informal rules and how they embed prejudices and stereotypes. And here I want to call out the work of Paola Bergallo that she's done on informal rules in Argentina. We need much more work on how informal rules are developed in the health sector, in part because of the gender hierarchy in the health sector. Health professionals get away with developing informal rules that are counter to the actual law and constitutional and human rights principles. And Paola, in her work, has opened my eyes to the importance of how informal rules embed prejudices. Far more work is needed on ethical guidelines, and the FIGO guidelines are just a beginning. So that's what I've learned about some of the cases on reproductive health. I'm sure you have your own thoughts. But let me return now to reviewing the overall argument of my presentation. I've argued that understanding the prejudices, the pictures in our heads of women as degrading, is a first step, only a first step to eliminating discriminatory practices against women. And certainly the naming in the sexual assault cases of women as the sexual property of men and in the reproductive health cases as women as reproductive instruments is a very dramatic step. These kinds of discriminatory pictures can lead to degrading consequences. We have to understand that the contexts are very gendered, particularly in the health sector and in the military. These are gendered hierarchies where men have the positions of power and women have subordinate positions. It leads to sexism, it leads to misogyny, and sets conditions for further promotion of stereotypes. But given the nature of this Congress, I want to stress the importance of dismantling, the importance of how we might dismantle stereotypes. It requires a judiciary whose impartiality is not compromised by biased assumptions. We've seen through some of these decisions how we are privileged to have a judiciary whose impartiality has not been compromised by biased assumptions. And we need to work together to move forward across disciplines with social psychologists to determine the best methods to dismantle stereotypes moving forward. For further reading, you'll see the sites on the board, and I look forward to further discussions on how we might move forward together on this endeavor. Thank you.
Excellent. Thank you very much. La primera pregunta está en inglés. Can you comment on how gender stereotyping operates when we talk about intersectional discrimination, such as disability, trans, intersex, etc.?
Right. Yes. So it's important with multiple forms of discrimination, such as sex, race, sex, disability, to identify our prejudices with regard to the particular sex of the person, and then also to identify the stereotype, the prejudice with regard to disability. That's probably the first step. But there's a second step when it comes to multiple discrimination, because intersectional discrimination, it combines and it compounds. It's not just adding sex and disability. It's adding them, but it compounds into a different form of discrimination. So one has to think about a stereotype, a prejudice, about that compounded or intersectional form of discrimination. Now, I want to stress that the work on stereotyping is evolving, and I myself am probably not aware of how, say, sex and disability interact. But it's important to work with different people in these different areas to begin to articulate how these different identities interact and how we develop pictures in our heads to marginalize these particular group of people. I don't have any answers to this. The methodology we've developed in the book really related primarily to sexual stereotyping, physical stereotyping, and role stereotyping. But this is just a beginning, and that's why I stress we have to work together to build this field, to understand the prejudices that are compounded by different identities.
Thank you. Next question in English. La siguiente pregunta está dirigida a identificar de qué manera trabajar para erradicar los prejuicios y los estereotipos de los propios jueces y juezas en la administración de justicia. ¿De qué manera? Tal vez usted ya avanzó en hablar sobre el impacto del training, la capacitación, pero ¿qué otras estrategias combinadas tal vez en su experiencia pueden ser particularmente útiles para trabajar en la erradicación de estereotipos con ese conjunto de personas tan importantes en la administración de justicia?
So, these are all excellent questions. I haven't myself done judicial training, and even the term judicial training, some judges will take offense at because they don't think they need to be trained. I certainly need to be trained as a lawyer in social science and social psychology. So working with training institutes, at the national level, there are many judicial institutes that would be a first place to start. I'm very influenced by a former student, Adriana Ortega, who used to work at the gender unit of the Supreme Court of Mexico. And I would certainly start by talking to Adriana about the incredible successful work of that division in training judges at all levels. And where they're going with it, I don't know, but that's where I would start. And there are many different national programs for judges, and I'm sure there's other programs on training in prejudice, stereotyping, biased assumptions, and stigma. There's another very good network that I should call out here. It's the Stigma Network of IPAS that's really trying to work in the health sector on understanding how abortion is stigmatized and beginning to raise awareness of that phenomenon, and that we might borrow from that as well. So that's another network that's looking particularly at stigma, and after all, stereotyping is part of stigma. So we have a lot of work to do. These are excellent questions, and I don't have all the answers. I can just suggest how I would start. But let me just say that most of the work in the social psychology well, I shouldn't talk about the social psychology literature, but most of the interdisciplinary work with lawyers and social psychologists has been done in the work in the employment sector. Employment sector is a neat and tidy sector. You can understand how stereotyping has discriminatory consequences. Women aren't promoted because they're not pretty enough, or they're not compliant enough, or they're not nurturing enough, so they don't get promoted. So excellent work has been done in the employment sector. We've done much less in the health sector. We're just scratching the surface of stereotyping in the health sector. And I'm hoping that the work of IPAS around stigma will begin to educate us about how we can expand this work. Final thing I'll say about this is that the law is only one way of naming stereotypes, of naming pictures in our heads. There's some fantastic films that are terribly funny about how we treat men, how we treat women, how we treat disabled people, that allow us to step back and understand these prejudices. And I'm sure you all have examples of good films. We have a wonderful film festival in Toronto, and I always love to go to these films to understand how they convey prejudices and stereotypes. So the law is not the only way, and perhaps not the most effective way. Maybe there are other ways, like using film, using art.
Muchas gracias. Seguramente el trabajo para avanzar en la erradicación de los estereotipos que afectan la forma en que el derecho se aplica y la forma en que las personas tienen acceso a la justicia, requiere de estas estrategias combinadas que usted mencionaba recién, donde la capacitación, la formación de las futuras generaciones, de los jueces y juezas en ejercicio, pero de todas las personas que conviven y afectan e intersectan con el Poder Judicial de diferentes maneras, tengan que entrar en cuestión. Creo que la referencia que usted hacía a las estructuras que se están generando dentro de los propios poderes judiciales y el ejemplo de la Corte de México, la unidad de género es un excelente ejemplo que afortunadamente se está replicando en algunos otros países de la región con sus particularidades. Creo que son herramientas que están tratando también de incorporar estos otros mecanismos más novedosos, más interdisciplinarios para llegar a lo que finalmente son esas imágenes que usted mencionaba al principio, que tenemos en nuestras cabezas y que moldean la forma de ver el derecho, pero también de transitar la vida. No tenemos más tiempo, lamentablemente. Agradezco mucho las preguntas, pero sobre todo agradezco a la profesora Cook por su brillante exposición y ayudarnos a pensar en esto. Muchas gracias.